So while Reverend Billy Graham lived his life modestly in comparison, of course, to his wealth, the fact remains he still leaves behind a substantial financial legacy. It includes real estate holdings, book royalties, 2 nonprofit organizations now run by his son. And as we have reported, Reverend Graham's will was well planned, with none of the strife often found in legacies of this size, which is certainly good news for him and his entire family. In this morning's legal brief, the importance of estate planning. Attorney Penelope Hefner, principal at Sodoma Law Union, joining us now to tell us more about estate planning. It's something everybody knows sort of in the back of their mind, Penelope, they need to do.
Right.
Far fewer people actually take action on this than should. Let's start off then maybe by just talking about the importance of it, why we should do it in general. Because what happens if you don't?
So if you don't, then the North Carolina general statutes are going to decide what happens with your things, and that may or may not be the way that you actually desire for them to go.
Are there any kind of across-the-board rules in terms of if you have kids, they would go, first to your parents or your next of kin, that type of thing?
So not so much with the kids. For the actual assets, there's almost like a formula of who gets what and how much. And again, it may be to relatives that you're not close with, that you don't speak with, so that you definitely don't want that to happen. And with the kids, you're going to leave it up to a lot of fighting within the family. You don't want one set of grandparents pitted against another set of grandparents. So you just want to make it very clear as the parents what you want to see happen with your kids.
Okay, so let's break that down into all the different types of things that we need to cover here. Let's first go ahead and talk assets. Your home, your finances, things like that. How do you determine who gets what, and then how do you allocate that appropriately?
So using your last will and testament, that's going to be the document you use, and that's going to allow you to be very specific. You can do it in general, that you want it to go to a certain person. You can make specific bequests of individual items to individual people. You can do some things for nonprofits. So you've got a lot of freedom in your will to design it the way you want it.
Let's talk about the kids thing again then. That's a tough one, right? Because you think to yourself, a lot of people would sort of naturally, if they're close with their parents, have their children go to their parents, but then you have to think, well, your parents may not be living that much longer either.
So you want to have a declaration of guardianship, and that can happen in your last will and testament. And you want to designate the people, and then you want to designate a backup person. You can have a secondary person and even a third person, because absolutely you want this to be a document that can last, during the time that your children are minors.
And then of course, you also have the issue of a power of attorney. If something should happen to you, if you were in a medical state, right, where you're not able to make decisions for yourselves, those are the kinds of things you need to break down as well?
Right. So we've got a couple things with that. So we've got powers of attorney, and those can be durable or they can be medical, and that can be to designate someone to make those decisions for you. And then you've got something called a health care directive or a living will, and that's regarding end-of-life care. And that's so that decision is kind of taken away from a person, and they know what your wishes are should the worst happen.
One of the reasons that people don't do this or take their time, really, it takes them a long time to get around to it, it just feels like a daunting task. Do you have any guidelines in terms of what you can expect realistically, the amount of time and effort and money it would take for someone to actually do this?
Right. So, as far from a time perspective, you're going to have an initial meeting, and a lot of the concerns are going to be put at ease right there. So that attorney is going to answer your questions, listen to your wishes, provide you with a little bit of guidance, like that's realistic, that's not. Then they're going to prepare the documents based on that. And then you'll get the chance to review them. You'll come back in and have your signature witnessed and notarized. So it's not an overly cumbersome process. It's more just kind of getting over the mental hurdle of thinking about something that's not entirely pleasant. That
is very true. Penelope, thank you so much for the time. I appreciate the insight.
No problem.
Good information. You got it. Come back for more Good Day, guys. We're back here in 2 minutes. We'll see you.